Hello everyone, I Sanchali, the Associate Editor at Corporate Law Journal, will be discussing about the Consumer Protection E-Commerce Rule 2020, which has been recently notified by the central government to curb the unfair trade practices, misleading advertisements, and to protect the interests and the rights of the consumer. Before moving further, I request to you all, please subscribe to the channel and press the bell icon for more updates on corporate and commercial laws. The 2020 Consumer Protection E-Commerce Rules are a part of the Consumer Protection Act of 2019, Subclause ZG, Subsection 1, Section 101 of the Act. In reality, markets have been favoring the sellers and the sellers' profit margins by giving very little importance to the interest of the consumers. The gap is going on widening as e-commerce platforms have paid their way into the markets. Many legislations were brought across the globe to protect the consumers' interests. India, being a developing country, has always welcomed such dares and enacted the Competition Act of 2002 to ensure the real and fair competition in the markets. But what touches and reaches the individuals as consumers are the Consumer Protection Act. With the changing trend that is markets becoming virtual, bigger and better, it was vital to renovate the consumer protection law in its entirety. Moreover, not to forget that new challenges and required resources for the same were equally important reasons to build the consumer legislations. With this intention, the COPRA 2019 had come into effect. The core of the Act focuses on consumer interests and therefore it is more consumer centric right now. This could be evident when seen there with the territorial and pecuniary jurisdictions were altered accordingly. The complete focus was admitted to decreasing the misery of the consumers and travails and cubisomeness of the consumer forums. As every coin has two sides, this was a huge relief as well as a probe to misuse by the unprincipled litigants. The new rules also specify that setting up of a grievance office for review of the products and its delivery is very much necessary. The product and company information is always specified in detail on the business platform. Display of charges, or there must be a proper breakup of charges which are available to the consumer on the business platform. The new rules do not allow any cancellation charges. The central government has notified that the Consumer Protection E-Commerce Rules 2020 function on the grievance mechanism even though these solutions were already existing. The e-commerce opened new modes and methods of faster and easy transaction and at the same time worked on the unfair trade practices which were happening. The enlargement of the definition of the consumer under Section 2, Subsection 7 of the Act by including both online and offline transactions within the scope of buying goods and hiring services has made it necessary to closely look into e-commerce and online transaction. The Act specifically addresses the common faced problem by the consumers such as refusing to take back defective goods or refusing the refund amount. These rules are applicable to all goods and services brought or sold over the digital or electronic network, including the digital products, all models of e-commerce, including marketplace and inventory models of e-commerce, all e-commerce retailers, including the multi-channel, single-brand retailers and single-brand retailers in single or multiple formats, all forms of unfair trade practices across all models of e-commerce. The legislation intends to keep the consumer's interest at the peak and also clearly defines the relevant players of the e-commerce space such as e-commerce entity, inventory e-commerce entity, and the marketplace e-commerce entity as well as the seller. The rules are applicable to companies which are not established in India but deliver to the Indian consumers. The important terms on the e-commerce 2020 for every individual to know are e-commerce entity, grievance, information, inventory, marketplace, platform, seller, and the user. Firstly, coming to the e-commerce entity, which means that any person who owns operates or manages the digital platform or electronic facility for electronic commerce, but does not include a seller offering his goods or services for sale on the marketplace e-commerce entity. Secondly, coming to grievance, which includes any complaints to an e-commerce entity regarding the violations of the provisions of the Act and the rules which are made. Thirdly, coming to information, which means the information regarding the product. Fourthly, the inventory e-commerce entity, which means an e-commerce entity which owns the inventory of goods or services and sells such goods or services directly to the consumers and shall include the single brand retailers and multi-channel single brand retailers. Fifthly, coming to the marketplace e-commerce entity, which means that an e-commerce entity which provides an information technology platform on a digital or electronic network to facilitate the transaction between the buyers and the sellers. Sixthly, coming to platform, which means an online interface in the form of any software including a website or a part of the application which includes through mobile as well. Seventhly, coming to the seller, which means the product seller. And eighthly, which means the user, as it is any person who accesses or avails any computer resource for an e-commerce entity. The company should be incorporated under the Companies Act of 1956 or the Companies Act of 2013. It can also be a foreign company which is incorporated under Section 2 of the Companies Act 2013. The foreign company can be an office, branch or an agency outside India but should be owned by a person who is an Indian resident. The company should appoint a nodal person who will ensure that there is proper obedience with the provision of the Act and rules. The Act also ensures that there will be no more tailored responses to grievances. The players have to display the contact number, email, fax, landline and mobile number of the customer care or grievance officer. The entities have to set up a grievance redressal mechanism that looks at the number of complaints and generally received from India. The complaints have to be acknowledged within a time span of 48 hours. Henceforth, after the application of this law, the platforms are not allowed to levy any cancellation fees when the customer cancels the order unless the entity also submits to incur the charges if it unilaterally cancels the order for any reason. The marketplace e-commerce entities are now bound to secure an undertaking from the seller that description, images, etc. of the good on the websites or applications are accurate and correspond directly to the actual goods or services. The platforms are now required to give information such as the names and the detail of the website, email address, and the other informations which are required for communication with the seller for dispute resolution to the consumer. E-commerce platforms are not allowed to record the automatic consent of the consumer. The refund policies will be subjugated by the rules of the Reserve Bank of India. The e-commerce platform cannot manipulate with the price, which will be an unfair advantage to the platform. There will be no discrimination on the class of the consumer. The e-commerce platform must ensure that the product information they receive from the seller is accurately described on the platform. There should be no discrepancy in the image, color, appearance, and quality of the product. The details of the seller and his business should be properly displayed on the portal so that the consumer can access it easily. A ticket number should be given to each of the consumer where they can track their lodged complaint. Proper information about the return policy, security, guarantee, and warranty of the product should also be mentioned. There should be proper and reasonable information of the seller in case they have breached anything on their behalf, which is based on the Copyrights Act of 1957. Duties of the seller and the e-commerce entities are explained together because both of them have the same functions. Firstly, there will be no unfair trade practices allowed on the business platform. Secondly, they are not allowed to misrepresent the product or falsely represent themselves in order to write good reviews about the product. It is necessary for them to appoint a consumer grievance officer to rectify the complaints in a clear, effective and efficient manner, they are hereby not allowed to refuse the return requests of the good or discontinue the services or refuse to return the refund consideration if the goods or services turn defective or do not match the specifications displayed on the platform, or if the delivery is made late. In conclusion, the latest changes added to the Act make it more consumer oriented and is at par with the international standards of the consumer laws. The breach of these rules will attract the provisions of the Act, and therefore no e-commerce companies can escape from these rules. Penal action of the Consumer Protection Act 2019 will be taken against those e-commerce entities who violate the provisions of these new rules.